Hello, everyone. For those joining online, you'll see this in a couple of hours, and thank you to the people who came today. We've got the LSS Property B revision seminar, and I am recording. Good. But before we begin, I'd like to pay my respects to the people of the Kulin Nations, from whose land I join online from today, and extend those respects to their elders past and present. Also, we have the sponsors for today, and as usual, Gilbert and Tobin, Cause Chambers Westgarth, Clayton Utes, and King and Wood Mallisons. So I guess my goal for today is to help you get into these firms. Um, all right, academic integrity statement. I'm going to make this in full again because I think your chief examiner warned you about using sketch notes. I think last year's exam there was a problem with people making the same mistake over and over again. That's not a good look. Um, the Monash LSS strictly condemns academic misconduct and has a zero tolerance policy towards persons who are found to have breached their academic integrity by misusing our educational services. The Student Tutorials Program, the STP, is a purely supplementary resource aiming to provide extra assistance to students. A student should primarily engage with faculty-run seminars, workshops, and tutorials, etc., as STP resources cannot be solely relied on for learning. While our LSS tutors work hard to deliver value, the unit content, reading guides, and the law can all change. Consequently, students must exercise their own discretion when using our resources. And yeah, refer to your chief examiner and faculty staff. Okay, had quite a few Q&A questions come through, so I thought I'd start off with this, just in case the practice problems don't accurately or adequately deal with it. I think one person sent through in about, I think, 6 questions, so that was helpful. But the first, what happens if the proceeds of sale are insufficient to cover the debt? Is the mortgagor liable for any shortfall? Good question. It's a relatively complicated one. If the mortgage is, it's okay, it's your standard mortgage and it's between the mortgagor and the mortgagee, there's no fraud. The person who owns the land has actually entered into the mortgage. Um, if the proceeds of sale are insufficient and the security interest doesn't satisfy the bank's debt, they absolutely can sue in debt on the personal covenant in contract. They can bring an action in contract to basically make the mortgagor liable for the rest. Seems harsh, um, but that's the way it is. You've defaulted, and you suffer the consequences. It's a bit more complex if the mortgage is fraudulent. If it's registered, if it's a registered fraudulent mortgage, um, it will depend if it's an all monies mortgage or a traditional mortgage. If it's a traditional mortgage, the personal covenant to repay will be in the memorandum of mortgage that's registered. And it will therefore also be indefeasible. So not only will the security interest be indefeasible, as will um, the covenant to repay. So they can be sued in an all monies mortgage. It's different. Um, so the off register memorandum has to make sufficient uh, shall you say, reference to the personal covenant to repay that is off the mortgage, off the title, sorry, um, to determine whether that's indefeasible. There's also been a change of position, I think, in statute, um, which limits the possibility of the bank suing a mortgagor who's been defrauded. Um, and those are your sections, I think, 87E and D and 110(4)(c), which are good to work through. They're pretty simple. I think I've gone through them in one of my past seminars. I don't want to spend too much time explaining it today, but the answer to that question is it depends on whether the mortgage is fraudulent or not. If it's not fraudulent, the mortgagor is pretty much screwed because there's a valid contract between the bank and themselves. So that's the answer to that one. In Zerky, Zachary in Zachary, was the mother's title defeasible or indefeasible? Well, the first answer to that first question was it was indefeasible, sorry, defeasible, because of the in personam exception. And the second part of that question is what was the purpose and role of the in personam exception in this case, and its relevance more broadly to this topic? Yeah, great question. As I was talking about in my tutorial, um, the mother was a volunteer, but effectively the court, so she should have been defeasible on that basis alone, according to the traditional position in Victoria, but the court threw it out. So they had to rely on the in personam exception to challenge her title. So that's where impersonum fit in. I think that's what you're asking, like how does it intertwine with the volunteers exception? Um, do the compensation provisions of the TLA provide adequate insurance against the losses created by the principle of indefeasibility? Yes, they very much do. You have to have a compensation provision, and it helps with some of the harshness created by the torrent system. It makes it more efficient and effective. So remember that for your policy questions. Um, some things you can talk about though, when you have a trust is lost to a registration. So if you lose your equitable and unregistered trust interest, you can't register a trust as far as I'm aware. You're not protected. So you can talk about that. It's pretty harsh in your policy questions. The trust is a very common wealth management tool. Very, it's not some obscure exception that will never come up in practice. Or I don't know, but it's trusts aren't obscure. So that the fact that you can't be insured against for losses under the trust, um, uh, that's pretty harsh. So perhaps it doesn't provide adequate insurance in that regard. But generally, yes, it does. If you look at the Section 110(1) provision, which stakes out someone's entitlement to be indemnified or insured from the Consolidated Revenue Fund. It's very broad. Very few situations will fall outside of it. In relation to this, is a person who is deprived of land by fraud of his or her solicitor entitled to be indemnified under the TLA? If not, what remedies are available to them? So that's clearly a reference to Section 110(3)(a), which is the exception for the fraud of an agent. If your loss has been caused by your own agent, you are liable for it. Yeah. So yes, they can claim because that section is dealing with reasonableness and lack of prudence. So if your solicitor is stupid, which if they've gone to Monash law, they won't be allegedly. Um, you know, if they're stupid and they're careless, yeah, you'll absolutely not be able to claim if they're stupid. Their stupidity and negligence is what's caused the loss. But if it's their fraud, they're not your agent in that respect. They're acting beyond the scope of their agency. You have not retained them to commit a fraud. So they're not your they weren't your agent in committing the fraud that's caused your loss. So the Section 110(3) exception does not apply, and you can cover. You can be indemnified. All right. This is a great question. This is my favorite one. Can you explain in more detail the different approaches relating to volunteers and indefeasibility in case it comes up as a policy question? And again, this is part of the reason why I wanted to deal with this at the start. In my opinion, this is a very good policy question. And I know I haven't really talked about policy much throughout the semester under instruction. But yeah, so should volunteers get indefeasibility? There's a key argument for it. It's in favor of yes, because the volunteer is the registered proprietor. So if you're going to have a torrent system, the objective of the torrent system is to create efficient dealings in land. You want to be able to look at the torrents, the register, the folio for the land, and say, yes, that person who's on the register has the interest. That's who I need to deal with. That's who I need to get the interest off. It's fine. It's perfect. That's the whole point of the system, really. And if you have volunteers on the title, not getting indefeasibility, you don't have that benefit. All of a sudden, you're almost back in a general law land situation where you need to look behind the register, behind the folio, and say, well, okay, well, if they're a volunteer, are there any other competing, are there any other unregistered interests there that I need to be careful of? And that's really important for a bank who's going to be lending. It's very easy to foresee a situation where there's a volunteer who's a registered proprietor going out to get a mortgage. And banks often take equitable mortgages because it's cheaper. They don't have to pay the registration fee, and usually they're secure. It's easy to foresee that if you have a volunteer who's not indefeasible, but they look like they are on the title because they're registered, there might be another first equitable mortgage lurking beneath the shadows. And that's not a great outcome for the banks. It's not a great outcome for the national economy either. So that's one big argument for it. a big argument against volunteers getting into feasibility is that it can be a mechanism of fraud. So, as you may have seen in, or as you may come to see in many of the practice exams on your Monash Law exam drive, which allegedly exists in breach of the Commonwealth Act, some Commonwealth Act, I don't think, copyright. You'll see that you might be having someone who's got no money and is the registered proprietor of the property, has an equitable mortgage charged against the land, and then simply transfers it to their 8-year-old son who's got no idea about what interests are being affected by that transfer. And he goes on and registers. Maybe let's make him 18 so he can actually go register himself without having, I don't know, some guardian do it for him or his father or his mother. If that volunteer registers, that bank's mortgage, the first one's completely lost. So you can see how it'd be very easy for, particularly say property developers who've got equitable mortgages to just transfer the property to someone and defeat the claim of that first equitable mortgagee, and just move on and start afresh. So in that way, it's an instrument of fraud because it's very easy to transfer some property to someone gratuitously. Um, so that's what I'd say there. I think that's a good discussion of it. That's going off my policy exam preparation doc that I had made prior to the exam. So yeah, and this brings me to the last question. Best strategy, please. A very vague question. Um, the best strategy on the whole is to avoid scripting your answers. You need to be flexible. I'm sure you can get your distinction or credit by doing exam scripts, or maybe, it might work out for you really well. But try be flexible in answering the question, particularly for questions about mortgagees' powers of sale, whether it was validly exercised. You need to be ready to have a serious discussion of the facts. On my exam, I had a question about power of sale, and it was entirely fact-based. I don't think I used the law very much. You have your statement of law, and there's about a page of facts, and just going, okay, what does that mean? What does that mean? What does that mean? How do I analyze that fact? And if you have a script, and you're just mindlessly applying it, yeah, I don't know. I can't imagine I've never made a script. I can't imagine that's a prudent strategy, particularly in this subject. But one thing that you can perhaps script is your policy questions. Now, best strategy, I don't want to get into any trouble here, but what I did with my lecturers from last year, I opened up every PowerPoint slide from each of the lectures. This took me like 5 hours. So if you don't want to do this, fair enough. But I did command search and put the question mark sign or character into the search and went through all 300 options. And I did this on the reading guide too. And I looked for every question mark and every potential policy question. And I found about 15, 16. And I prepared for those, which you can and should do. Um, you know, I remember sitting in my exam being very happy with myself because the night before I'd looked at one of my lecturer's slides and did the same question mark thing. And the verbatim, the question on the PowerPoint slide appeared on my exam. I'm not saying it's going to be the same this year, but at least it'll give you a very good idea of what is going to be discussed. It might take a bit of time, but again, it's worth it. Okay, we now have the question component. I'm very sorry about the unattractiveness of this slide. It sucks, but this is just so I can stop having to toggle between screens. So I'd advise you, or it'd be great if you can get up the exams that I sent you, or from your email, or the exam drive, which is in existence apparently, and follow along with me. But I'll read you the facts like like a story. So this is from the question 3 from the 2018 exam. I only took this one question because the first question was unrelated. It was about the stuff from the topics 1 and 2, which I understand are inaccessible. And question 2 is from your tutorial, and I get into big trouble if I talk about that stuff. So I've decided, to not have an academic misconduct issue. And I'm going to go just for this question, and I've got the 2015 exam coming up shortly. Gavin owns a small house on a large block of land close to Monash University. Resides there with all his children. They're in their late teens or early 20s, and some of them are in their high school. All of them, what the fuck? All of them are either high school or university students. That's a poorly drafted question. In an attempt to boost his retirement funds and at the same time create more living space, Gavin decides to subdivide his property, build a house on the vacant block, and allow his two older children to live in it rent-free until they've finished their education and then sell it. Wow. Mogul. The subdivision goes ahead and Gavin becomes the registered proprietor of both blocks. The original house is on Block A, and the new house is to be built on Block B. Block B overlooks a neglected park, which is a known haunt for drug dealers. Yeah, it's not going to help the property value. The council has recently voted to upgrade the park and make it family friendly by installing a huge playground, barbecues, and skateboard area. Nice. Gavin needs to borrow money to build the new house on Block B. He secures a loan for $200,000 from Busy Bank. He's going to default, I reckon, in return for giving the bank a registered mortgage over Block B. Here we go. Gavin soon realizes that he cannot handle the mortgage repayments. And so, instead of allowing his two older children to live there rent-free, Gavin leases Block B to them for 18 months. Ding, ding, ding. 18 months. You can't register that mortgage. That lease. So it's going to be an unregistered leasehold interest for the children. Store that in the mind. It's going to be relevant to one of your little questions later. Busy Bank is aware that two of Gavin's children live in the house on Block B, but was not informed that a lease had been entered into. Damn. Gavin is subsequently retrenched and defaults on his mortgage. Retrenched. Wow, he was dismissed. Busy Bank wants to sell Block B with vacant possession. After serving the requisite notices on Gavin, again, store that in the mind. If you start going off on a big excursus about whether the notices were proper or, whether the NCCC applies to this mortgage, you will have been wasting words. You might as well have written about your weekend on the exam. And Busy Bank gets a sworn valuation of the property. That's a good thing. The property is valued between $590,000 and $615,000. Busy Bank retains Sally, a local estate agent, which they're allowed to do, to handle the sale on its behalf. Sally informs Busy Bank that the market has slowed and that houses that would, until fairly recently, have sold in a few days are now taking several weeks, sometimes months to sell. She advises the bank to sell privately rather than at auction and proposes a modest advertising budget. The bank agrees to Sally's suggestions, and then she proceeds to instruct her administrative assistant to arrange for advertisements to be placed in a local paper and online over a number of weeks. All looks fairly good. The house is advertised at $590,000 to $615,000. Now the problems start for you to analyse. No mention is made of the council's decision regarding the park. The advertisements depict photographs of the house with no gardening or landscaping, but in the weeks that have ensued since it was first put on market, Gavin has paved the entrance to the house, established a garden and outdoor eating area, and put a gate through to the park. See, that's an improvement. Should they have updated the photos? The administrative assistant at the real estate agency arranges for the entire advertising budget to be spent in the first 2 weeks, and no advertisements have appeared in print or online since then. Another problem. And before I give you the answer, two things to note. This sort of backs up what I was saying about the fact that the script isn't going to help you, particularly in a question like this. There's no case law for a failure to update photos. There's no case law for the administrative assistant being an idiot and spending all the budget in 2 weeks and the advertisements aren't running. So, this sale is obviously taking a fair amount of time. There's no case law for that. So if you don't have your eyes open to the facts and you're just, jotting down your script, you'll miss this and you'll get punished for it because all the marks are going to be literally in this last few words, the last few sentences. Have you analyzed those facts? There's more. Bob, the builder of the house on Block B, drives past the house one day and notices that the property is for sale. He contacts Sally, who he happens to know, and she informs him that the market is so slow that if he were to offer 550,000, she would accept it, or advise to accept it. Both Bob and Sally are under the impression that Gavin's two eldest children are living in the house on a Block B under a bare license, so not a proprietary interest, and that Bob would be getting vacant possession if he purchased the property. Bob proceeds to offer $550,000. Busy Bank accepts it, and an unconditional contract of sale is signed. First question. Gavin believes that Busy Bank has improperly exercised his power of sale. Is he correct? Okay, has the power of sale arisen, as I was saying before? Yes, it has. The facts state that the requisite notices have been served. There is no issue here. Do not talk about it. Now, the mortgagee's duty when exercising their right of sale. Remember, the mortgagee has two duties that they must observe: the duty to act in good faith and in the best interest of the mortgagor. Now, start off with your law. Define the tests. Good faith. Is there a subjective lack of honesty on the part of the mortgagee? By now you know what good faith means. Are they acting in a way with moral turpitude, corruption? I think Property B is a very good subject to get you to understand what actual fraud and dishonesty is. Best interests. Has the mortgagee objectively taken steps to secure the best price for the mortgagor? So the good faith test is very much looking at the intent, the lack of honest intent by the mortgagee. Best interests is looking at the objective outcome. Have they obtained really the best price for the mortgagor? That's the question. So you see the difference there. Good faith. There's a red herring on these facts. Bob contacts Sally. So Sally's the agent selling the property on behalf of the mortgagee. She informs him that the market is so slow that if he were to offer the bank 550,000, she would advise to accept. Now, these two parties are known to each other. Now, they clearly want you to be talking about good faith here. But is there moral turpitude? A good understanding of the facts would be that the property isn't selling, it's sitting, and she's simply told someone to make an offer. It is not value, the price they've obtained is less than the valuation, but you have to be responsive to the fact that in the facts, the property market is shitting itself, I think. So, just because the price is lower than the valuations, which were made at the time the property market was booming and whatnot, if they obtain a price that's less than, because of market conditions, essentially, the fact that she's told someone who she knows to make an offer, and they do make an offer, and then they accept it, there being no other options or offers on the facts, there's no moral turpitude here. This is a very weak analogy to gold sale nominees, which is, I think, your only case about good faith. Gold sale, they left money on the table, and the mortgagee sold the property rather, to one of their clients at an undervalue, knowing that there was more money on the table. Now, that's very bad behavior. That is improper conduct. That is moral turpitude. Here, just because the fact that because the parties know each other, the agent for the mortgagee and the purchaser, does not cry bad faith. The only reason that the $550,000 was attained, and it's lower than the valuations, is not because Sally's offered Bob some amazing deal. It's because the property is worth far less than they thought it was, and the market has dictated that. So no bad faith here. So there's no breach of that duty. Best interests. Now it gets interesting. The duty to advertise, question mark. The judge, forget his name, in Henry Roach Petroleum, suggests that there is a positive duty to advertise. However, the court in Vasiliou suggests that the focus should be whether the best price was obtained. The advertisements failed to include information about the park plans, which would be attractive for buyers. Yep. The property was not advertised throughout the sales cycle, and all advertisements were done at the start. Naturally, you can see how that can mean that they won't be generating interest throughout the sales cycle. That's usually not what you'd want to do. you'd want to be advertising it throughout. There was a failure to update the photos to put the house in its best light. Again, you can't get this wrong if you deal with the facts and give your opinion on whether you think the bank has taken objectively steps to obtain the best price. But I would say that given the court in Vasiliou has shifted the focus on whether the best price was obtained, a proper price, I would deal with the fact that, you know, no one was offering any money. They've got $550,000 for it, which is a bit less than the lower end of their valuation. But the property market was screwed. So I'd say this is a proper price, and there probably isn't a breach of duty here caused by the failure to advertise. I'd stress to you that advertisement is not as important in the property market as, say, the product market, where you have to, I don't know, companies have to flog you some strange consumable good. Marketing's important there. But at the end of the day, if there's property for sale, someone's going to find it. So I think you'd be hard pressed to say that the fact that they've got, $550,000 rather than their valuation amount, 590 to 615, was caused by the failure to advertise appropriately. So I think they're okay here, to be honest. But again, completely valid if you come to the opposite conclusion, so long as you picked out these three facts and talked about them. It's not the most onerous task. You just have to, think about it and just really like read the facts on the case on the exam. It sounds stupid, or it sounds like obvious, but you'd be surprised that if you don't slow down, you'll just miss this stuff. Particularly if you're constantly looking for analogies with cases in this topic 3, which is a good thing to do, but just be cognizant that not every fact will be analogous to the cases. So on my exam, we had a mortgagee selling the property, and they decided to sell the property on AFL Grand Final day. Now, I've never read a reported decision about that, but is that taking a good? Is that acting? Is that a way to conduct a sale that will achieve the best price for the mortgagor? No, of course not. Everyone's watching the footy. You know, so it's important to be really like hypersensitive to different facts and what they say about whether the mortgagee has actually tried to get the best price. But keeping in mind again the duty to advertise, and I think this is what got a lot of students on my exam. I'd suspect. I think people did quite poorly, from what I heard. Yeah, the duty to advertise is perhaps not as strong as they say it is in Henry Roach. And Vasiliou is basically saying that if they obtain the proper price, they could have put, only advertise the property on Gumtree, but it'll be okay. So they're really downplaying the significance of advertisement. Finally, some bring up and dismiss points. The market is very slow, but you'll note that there is no duty to wait for a more propitious time to sell Henry Roach. They can realize their security interest as soon as they want. There is a positive duty to obtain a sworn valuation, and that's as part of the duty to act in the best interest of the mortgagor, and they've done that. And that's from Henry Roach again. So get those two things in there. That's a couple of bonus marks for you, and you'll be on your way to full marks. So ultimately, no breach of duty. Hooray. And the second question is whether Gavin can obtain an injunction to prevent the sale if he is correct and the mortgagee has breached his duty. First, you have to understand what the consequences of Gavin being correct is. If Gavin is correct, the mortgagee will have breached his duty in selling the property, and that gives Gavin an equity to set aside a fraudulent transaction. Again, fraudulent here really means equitable fraud. So it doesn't mean that the mortgagee has acted, the mortgagee, can't wait to be done with this. The mortgagee, has purposely screwed him over. If they haven't acted in his best interests, according to the duty, that'll be equitable fraud, and he can set aside the transaction. The sale to Bob is yet to be registered. So Bob has an equitable interest in the property. Now, the question is asking you about an injunction. So I'd advise you to avoid getting into some discussion about Swanston Mortgage, which is a case where they said that the equity is not a caveatable interest. Obviously, if it was a caveatable interest, as it is in other states and probably will be in Victoria as soon as that case is challenged, um, he could simply caveat his interest and he wouldn't have to worry about an injunction. But the problem is in Victoria, you do have to worry about an injunction because the caveat option is not available to you. Remember, in Victoria, you need a separate and distinct interest from your fee simple if you're the registered proprietor and the mortgagee screwed you over. You can't simply note on your title um, uh, improper sale equity, have an equity to set it aside because it's not an equitable interest according to the court. It's not caveatable. So don't talk about that again. You may as well have written about your weekend. Well, it's probably not too bad to bring up in like a sentence maybe at the end, the very end, once you're confident you've covered everything else off. Injunction. Gavin can do a couple of things here. In theory, Gavin still retains the legal title to the property because Bob is yet to be registered, so the sale's not completed yet, or it's not. The transfer is not completed at law. Um, and he can use his legal interest to stake out a claim to injunct Bob because his legal interest is stronger than Bob's weaker equitable interest. Further, that's right. Even if Gavin's interest was treated as equitable, it would still win in a priority contest with Bob's equitable interest. And this is your topic 8 stuff, but deal with it really briefly. Uh, Gavin's interest comes prior in time, so he's got that advantage. And there's no failure to caveat. So you know how on topic 8, most of the cases are, oh, what's the significance of failing to caveat? Well, here, Gavin can't caveat because he doesn't have a caveatable interest per Swanston, as we just discussed. So that's where you bring up Swanston because it's relevant there. So you can't hold his failure to caveat against him and then therefore postpone his interest, his prior equitable interest, to Bob's on the basis of the caveat because that would be ridiculous. So he wins. So he's going to get an injunction. But as my lecturers stressed to me, and as I stressed on my exam, I had one of these questions. You're going to get one, I think. Um, this course of action is going to be entirely fruitless for poor Gavin because you have to go to court. You have to get an injunction. So there's a few things that are wrong with that. First, it takes time to go to court and get your injunction. Um, Now, Bob has entered into a contract of sale. Um, I don't know if he's settled yet, but settlement will be what, 30, well, 60 days, let's say. And then he can just go register. So he can register before Gavin can get his court hearing, which will, I don't know, I think it takes like 90, 100 days to go to court. That's if you're lucky. Um, so, you know, there's a time thing there. So as soon as Bob registers, it's see you later, Gavin. So if it takes him too much time to go get his injunction, the injunction, like it's not going to do anything. It won't be granted if Bob is registered. Second, and this is, even more practical point, Gavin's probably poor. Um, he is he has defaulted on his mortgage. I don't think it was a tactical default, so to speak. I don't know, yeah. Anyway, he's got no money. He's not going to be able to afford to go to court to get his injunction. So, um, so I always found this strange, like doing this in the exam. We'd be, oh, Gavin, you can do this. Gavin, you can do that, but you're broke, and it's going to take too long. So, poor Gavin, you're still going to lose. Put that in the answers. They like that. I know that for a fact because I did it on my exam, and it was well received. Okay, if Bob becomes registered proprietor, will Gavin's two children have a right to remain in the house? Remember, I told you to store in the back of their mind that they have a leasehold interest. Now, it doesn't tell you that it's not registered, but it's pretty easy to tell it's not registered because they have an 18-month lease. You can't register that. I think, what is the section? If I get this right, I'm awesome. It's section, I'm going to go with 66 of the Transfer of Land Act. Is that right? No, it's probably not. Anyway, you can't register a lease if it's less than 3 years, 3 years young. So yeah, it's an unregistered interest. And now Bob's registered. Now you should be thinking, whoa, what's going to happen to their unregistered interest if there's a registered interest? Well, indefeasibility. Uh, so, can the children rely on an exception to indefeasibility to protect their unregistered interest? They can, arguably. Section 42(2)(e), they have an unregistered interest in possession, the leasehold estate. Now, remember the operation of Section 42(2)(e). It transforms the priority dispute from an unregistered interest to a registered interest, an unregistered versus a registered to an unregistered versus unregistered. It doesn't automatically guarantee victory to the children. However, there's a separate notice test, it seems, and they are in possession of the property. So, as per the majority and perpetual trustee, they'll likely win the priority dispute on the basis of a constructive notice or notice, more generally. In the facts of the exam, it says, oh, Bob thinks they're under a license. Sorry, mate. They're in possession, so that you're going to be taken as knowing that as knowing what interest they have. So that'll defeat his claim. So they'll win that priority dispute. There was an alternative way to answer this exam question, because the mortgagee who sold the property to Bob had no knowledge of the lease. So if a mortgage comes before a lease, which it did on this case, the mortgagee can have the lease struck off under Section 87. And the examiners appeared to accept that. But I think, and I humbly submit, that they were wrong. On the facts, nothing says that the mortgagee has taken any action whatsoever to get to void the lease. They haven't, made any communication with the children, and the mortgagee is a completely different party to Bob. Bob doesn't have his rights under Section 87C because he's not the mortgagee. So I think the answers are wrong in this respect, and they said they'd either tolerate a Section 42(2)(e) approach or a Section 87 approach. You can do both. I think, I think the 87 one's wrong in this case because 87 is about providing protection to mortgagees against leases that come after their registration. But here, the mortgagee's out of the picture. They've sold to Bob. The question is whether Bob and his registered interest is subject to 42(2)(e) and Gavin's children's rights. So I don't see how the mortgagee's rights come into play here. Maybe they do, and feel free to correct me and speak up now if you disagree, but I think 42(2)(e) is the way to go here, and they'll win. So Gavin can remain. Gavin's kids, rather. Another question, this is from 2015, semester 2 exam, question 1. Angus is the registered proprietor of property. Angus is registered as proprietor, that's fair enough, actually, of a property named Brismore, over which G&I Bank has a first registered mortgage. Angus operates a business in which he takes people on trips overseas on foodie tours. That's a nice job. For these purposes, he uses the services of a travel agent, Paris. That's good. With whom he developed a good and trusted professional relationship. In January 2013, Paris told Angus that she needed money for cash flow in her travel agency business. And in view of her long-standing relationship with Angus as a client of the agency, asked Angus if he would be prepared to guarantee a loan of $30,000 that he was obtaining from Response Finance. Angus agreed, but only on the basis that the loan would not exceed $30,000 and would not put his house at risk. At Paris's request, Angus provided Paris with various documents that Response Finance required before it would accept Angus as a guarantor. These included a copy of Angus's driver's license and a statement of account from his mortgage, along with titles of particulars for Brismore. He expected to receive a copy of his guarantee documents before committing to the guarantee, but no documents were ever received. In fact, Paris had no intention of obtaining a personal loan of $30,000 guaranteed by Angus. Rather, she wanted to use the documents and other particulars Angus had given her for the purposes of obtaining a more substantial loan to herself that would be secured by a mortgage over Brismore. It's not very nice, Paris. She submitted a loan application to Response Finance, along with the various documents provided to her by Angus and a statement of her assets. She explained that Angus was happy to provide Brismore as security and had asked her to handle the transaction for him. Some weeks later, Response formally approved a 3-month loan of $130,000, and that was to be secured by an unregistered second mortgage over Brismore. It was a condition of the loan that the unregistered mortgage would be registered only in the event of default. Response appointed a solicitor, Fallon, to prepare the relevant mortgage documentation on its behalf. After making appropriate searches of title to Brismore, Fallon prepared the mortgage and, as instructed by Response, sent the mortgage to Paris with a letter addressed to her, but requesting that she give the mortgage to Angus so he could obtain independent legal advice and the effect of the mortgage advice about the effect of the mortgage on his interest in Brismore. So very much like Nathan and Schultz, or like a contrast to it. Nathan and Dollars and Cents, rather. The letter asked Paris to arrange for Angus to return to the Fallon the duly executed mortgage, together with a solicitor's certificate stating that independent advice had been obtained or provided to Angus. That's a key fact, and I'll go through it shortly. Fallon also requested advice as to the account into which the loan funds should be deposited. Is there more? God. A few days later, the signed and attested mortgage was returned to Fallon by Paris, along with the certificate that was signed by the solicitors. The signature on the mortgage was witnessed by B. Worth. A written memo signed by Paris and Angus directed Fallon to pay the loan funds into Paris's travel agency account at GNI. After execution of the mortgage by Response, and in accordance with the usual practice, Fallon prepared and filed a caveat against the title of Brismore, dispersed the funds to Paris's nominated account at GNI Bank, and retained Response's signed copy of the mortgage. Shortly after lodging the caveat, Fallon received a call from Angus, who informed him that he had received a letter from the Land Titles Office advising of the caveat having been lodged over Brismore. Angus denied that he had signed any of the mortgage documents. Ding ding, he's telling this to Fallon, and see what Fallon does next. He claimed to have no knowledge of the transaction, although he told Fallon that he knew Paris and that he had agreed to guarantee a $30,000 loan for a business, but was still waiting to receive the relevant documentation. Following this conversation, Fallon contacted Dougal at Response Finance and asked that he check Paris's file for any irregularities and to provide some other documentation bearing Angus's signature. Dougal found a copy of Angus's driver's license and committed this to Fallon. In the process of checking the file, Dougal also discovered the signature of Paris was missing on one of the internal bank documents used for approving the loan, so Dougal forged the signature himself to correct this administrative oversight. Again, another character comes into the story. Dougal, we'll be talking about you shortly, sir. On receipt of the emailed driver's license, Fallon carefully checked the signature against the mortgage document in his strong room and was disturbed to find substantial differences. So he understands now that, it definitely wasn't Angus who executed the mortgage. Fallon made no attempt to contact Angus or Paris, although there was no default under the mortgage at this stage. Fallon contacted GNI and requested an urgent consent to register the second mortgage against Angus's title to Brismore. GNI provided the consent and made the certificate of title to Brismore available at the Land Titles Office for the mortgage to be registered. The second mortgage was registered in March 2013 and was confirmed that Paris had forged all the signatures. Okay, advise Angus whether he has grounds to remove the second mortgage from the title to Brismore. I'm sorry about the long-winded facts. This was a very hard question from memory. I remember doing this one and it absolutely screwed me up. So that's why I wanted to go through it. So the second mortgage to Response, which is what we're asked about, is registered. So you're in the realm of indefeasibility here again, and your task is to find an exception for our friend Angus. Fraud, section 42. Paris is one of the actors who's fraudulent. Paris is quite clearly fraudulent in this whole ordeal. But the question is ultimately whether her fraud is relevant fraud. It has to be the fraud of the person who's on the register. So you have to bring her fraud home to the bank somehow. So, can she be said to be an agent of the bank in the mortgage process? Now, while Fallon, as agent of the bank, has tasked her to do some things, like getting the signatures, whatever, she appears to be a mere courier, and he's not placed complete reliance on her to fulfill the tasks. So this is really key for your understanding. And I found this practice exam for myself quite declaratory. Unlike in Nathan versus Dollars and Cents, Fallon has requested Angus to come back in person with the signed mortgage and with a solicitor's certificate to ensure he has legal advice. So in this way, unlike in Nathan, it is not as though Fallon only intended to deal with Angus through Paris as an agent. He's sending Paris to deliver the documents to him, and he wants Angus to come back. So that really looks like Paris is a mere courier and therefore not an agent. So you can't bring her fraud home to the bank. You could stop there, and that would be completely legitimate. But even if she was an agent, and if her fraud still can't be brought home, so consider the Australian approach to respondeat superior in Schultz versus Corwell properties. Uh, I mean, quite evidently, Paris is on a frolic of her own. So even if she was retained by the bank as an agent, she uh, is doing it for her own purposes. So again, not relevant fraud. So Paris, you'd end it here, but usually, uh, when you have the person who's actually doing the fraudulent actions, you don't really consider their actions too much because you're looking for the person who is brought home, or who's on the title rather. But this is one of those strange cases where you could argue that the person who's really the uh, agent of the fraud, in the sense that they're the one, the fraud is on their animus, they're doing it. Um, it could be relevant because of this whole agency principle. Um, So talk about it, but have a really nuanced understanding of agency. A lot of students on this exam, I think, reading the examiner's report, just saw that Fallon had gotten her to do some tasks, and they're like, "Oh, bang, agent, let's go talk about it." But she must not be a mere courier to be an agent. So, has the bank only intended to deal with Paris? No. So, if you get a future question where you might have this sort of similar agency principle come up, so you got the bank, they've got a third party trying to get to the person whose property they're trying to get a mortgage over, the mortgagor. Ask whether the bank is intending only to deal with the third party rather than the mortgagor himself or herself. And in this case, they're not. I think that was one of the harder points of the course to really get my head around. I liked this exam to do it. So you should go do this question after yourself and really hone that point in and read Nathan versus Dollars and Cents, because it's a great case. And my policy question was on it last year. Fallon. So Fallon's, yeah, he's messed it up. Fallon received a call from Angus, who basically told him that it wasn't him. So that's one. He noted the discrepancies in signatures, but also he actually wasn't authorized to register the mortgage. If you remember from the facts, it said that the mortgage was only to be registered upon default. He's registered it before default. So, I mean, this is really bad, Fallon. Uh, and what his relevant fraud is the act of registration. So, go back to Assets Co. and the general principles from the Privy Council, and as they were applied in AGC versus De Jager, presenting a document to the title office for registration that you know is ineffective or inappropriately executed is a fraud on the register and is relevant fraud for Section 42. So there's no doubt that Fallon sucks and it's a fraudulent act. Can it be brought home to the bank? Now, this is one of these strange cases where fraud can be brought home because you have that exception in Schultz and Corwell, which is about, is the person on the frolic of their own? And usually they will be on a frolic of their own. That's a tip for your exam, I think. Just be careful though, for these AGC versus De Jager type situations where they're not on a frolic. But generally, people commit fraud to advantage themselves, right? I mean, why would you do fraud otherwise? Unless you're a pathological liar or a sociopath or something, um, which, more power to you. But here, he's got no reason to do this other than his duty to the bank. And he's been tasked with perfecting the bank's mortgage and going about that, getting the signatures from Angus. So this is clearly within his remit. Remembering your agency principles and implied and actual authority from corporations law. And he's not on a frolic of his own. There's no personal benefit to him in registering the mortgage wrongfully. Yeah, the fraud exception will be made out here. It would perhaps be different if Fallon received a bonus for registering mortgages. That would be a personal benefit. That could be a frolic. But here, there's no reason that he's done it other than the fact that he's an employee of the bank. So, or not an employee, rather an agent. He's a solicitor. Dougal's committed to forgery on an internal bank document. As soon as you see that, you should be downplaying it. And he's also like the Clark and Russo. Sorry. So he basically said in the facts, I'm correcting this mere administrative oversight. So he's not exhibiting a good understanding of the property law system. He's an idiot, but he's not expressing moral turpitude. And in Russo, I think it was Ormiston J, Justice of Appeal. Ormiston, somebody smart, said that, if you're not consciously disregarding anyone's proprietary rights, you are not acting fraudulently uh, with actual fraud. Now, equitable fraud, go for your life, but just remember this isn't that equitable fraud is not within section 42, and it's really important. You need actual moral turpitude. You can't say, Dougal, you idiot. Dougal, you're so dumb. Dougal, you should have known. If ever you find yourself saying you should have known, stop. Well, if you find yourself saying you should have known and therefore actual fraud is being committed, stop and delete. Delete that sentence or a couple of sentences where you make that point because it shows a serious misunderstanding about what Section 42 fraud is. Actual. He's done it on purpose. He knows what he's doing. It's not really that theoretical. There's a clear difference between gross negligence or recklessness and intent. That's a theme that you've been learning throughout your whole degree. They must have actually intended to screw someone over, basically. And just be very careful before you want to have an understanding of that in your exam because this fraud exception, it's going to come up and in a big way. So having a good understanding of actual fraud, being actual fraud, moral turpitude, intention. Think about it in those terms, not gross negligence. Don't get yourself stuck. If you say gross negligence, not only will we not get a marks for it, your examiner will immediately start thinking that you don't know what you're talking about, which can have an effect on the rest of your mark subconsciously. It's human nature. Was the fraud operative? This is a relevant question because he had originally agreed to give some sort of loan as a guarantor. No, it's clearly operative. He only wanted a loan for 30,000. The loan was 130,000. He didn't want to provide security. He just wanted to be a guarantor. So, this loan is completely otherwise than what he'd envisaged giving. CF Ferguson, where the guy got exactly what he wanted through fraud of the bank officers. So, dismiss that quickly. How are we going for time? I want to try see if I can get some more questions from you guys at the end. Does anyone still watching? I've got two participants. Let me have a look. Wow, thanks guys. This is really, this is more than I've had all semester. So this is truly, I can't even express in percentage terms how much of an increase on the usual participants you guys are because, you know, no one's ever come. So anyway, I'm sure they'll watch the recording. Question 1B. Fango operates an automobile spare parts business in Coburg and is registered as proprietor of a property in Balwyn. It's called Willow Bank. In the leafy suburbs, they give their properties names, I think. Norfolk Finance is a registered proprietor of a $200,000 mortgage over Willow Bank, a property that is valued at $350,000. In 2015, Fango's business collapsed due to a downturn in the economy. He defaulted under his mortgage, and Norfolk Finance exercised its power of sale fraudulently by transferring Willow Bank to Evelyn, the wife of one of its directors, for $250,000. So stop there. The fact that they've literally told you in the facts that they've exercised their power of sale fraudulently, you don't have to go into much of an analysis to say here that there's an equity to set aside the transaction. It's sold at an undervalue and clearly in bad faith to a related party of the director, like in LATIC investments. So Evelyn becomes registered. So, and then on sold the property to Cameron for $400,000, but the property, the transfer is not registered. And then there's this weird fact at the end. Fango becomes aware of the fraud and lodges a caveat to prevent registration of the transfer. So here Cameron's got an equitable interest. It's not registered. So the question is, advise Cameron as to whether he can register his transfer of land. Forget injunctions because Fango is no longer on the title anymore because Evelyn became registered, even though it was a fraudulent transaction. Forget conjunctions, forget caveating. Fango no longer has a caveatable interest because of Swanston. So the only thing he can do is enter into the arena and engage Cameron in a priority dispute. So it's going to be Cameron's equitable interest going up against Fango's mere equity. And the priority dispute rules um, dictate that Cameron will win if he's a bona fide purchaser for value without notice of the prior interest. So he's paid money, he's not a volunteer, so he satisfies the first limit of the test here. But does he know of Fango's interest? Now, Fango's caveated, which suggests that constructive notice would be given to Cameron. So perhaps he loses Cameron on this test. I will note though, uh, this exam is very strange, particularly this last part of it. Fango can't caveat. I don't know why they've included the fact that he has caveated. Perhaps back then, because in 2015 there were some decisions in New South Wales and South Australia around that time that had overturned, or well, rather taken issue with the Victorian approach in Swanston. So perhaps the examiner was teaching them as though uh, Fango's interest was caveatable, his mere equity. Perhaps they were teaching it differently, but the way we've been taught it, Swanston Mortgage still stands, and he can't caveat. So generally, in this type of dispute on your exam, that last fact there that Fango lodged a caveat would not be there, and you'd be asked to do a priority dispute on everything here basically without that fact. And Cameron will win in that case. How's he expected to know about Fango's interest? It's not on the title anywhere, and he's paid value. So the priority dispute rule about bona fide purchases for value, that really, without notice, really favors the incoming party. So generally, Fango would lose a dispute like this. So I'd suggest to you that the exam would not have that fact about caveating because he can't. So yeah. Uh, anyway, good question to do. And yeah, read up on LaTeX investments. Great case. Oh, I've got it here off the dome. Okay, I'll stop here quickly. Do any of you participants have a question? I just don't want to run out of time. I'll wait, I don't know, 30 seconds before I continue. Any questions? Please ask me. Like, why not? You can put it in the chat if you want to. No, doesn't look like we have any bidders. Please send me, no, you can't send me an email. That's invalid or illegal, apparently. Put something in the Facebook chat if you want something answered. Um, Alan and Bree live together with their new unborn child. They've recently become engaged and decided to buy a house. Alan is a business consultant. That sounds like a real job, and wants to establish his own firm. Eventually, Bree will become Alan's assistant, so they will work close to home. Oh. Accordingly, the property that Alan and Bree decided to buy has a separate garage in the backyard that will be renovated to become Alan's office. The purchase price is $300,000. Bree pays the deposit of $30,000 from her savings. They agree that Alan will pay a similar amount to renovate the garage after they move in. On his accountant's advice, Alan takes up a business loan from Startup Finance to pay the balance. The loan will be secured by a registered mortgage. A Startup Finance requires the property to be put in Alan's name only, as he is the sole borrower named in the mortgage. So again, this fact, like part of this question was about resulting in constructive trust, but I swear it's relevant to you. Settlement occurs, and within 6 months after the garage renovation costing $30,000 is complete, Alan paid the cost of the renovations as was agreed. Alan's business was going well. He asked Bree for a further $30,000 to hire staff. Alan assures Bree that as soon as their business is doing well, he will give her a share of the property to recognise her contribution. Common intention, constructive trust. Perhaps Bree's concerned, yada yada yada. I'll skip through a bunch of this stuff. Alan persuades her to hold off doing anything formal, as Alan thinks it will be difficult to get startup finance to agree so soon to a mortgage term. Next day, there's another note saying, don't worry, I'll give you an interest that's common intention, constructive trust stuff, not relevant for you per se. Alan hires a consultant, that's nice. Alan uses most of the money Bree gave him to cover the wage and puts down a deposit on an expensive high-tech software firm, IT Limited. The balance owed to IT Ltd, IT Limited, is secured by an unregistered mortgage over the property. So with new staff and software, oh God, who cares? Oh, so Alan's cheating on Bree. Oh, dude, not really relevant to the priority dispute, I don't think. Although you do consider the conduct of the other party in some cases. So, you know, caught out, Alan tells Bree that their relationship's over. So that's clearly looking at joint venture constructive trust stuff. But the second part of the question is advise Bree whether her interests are subject to the mortgage to IT Ltd. So I don't know if you'd get in your exam a question with so much topic 1 and 2 facts on it. But why it's relevant here is because she has an unregistered interest in the constructive trust or a resulting trust because she provided some of the money for the purchase. So she has 2 unregistered interests. Can't register a constructive trust and you can't register a resulting trust. They're not in writing. So that is competing with IT Limited's unregistered mortgage. You see, bang, there's a dispute. And it's between 2 unregistered unregistered interests. So you are looking at topic 8. Hurrah. Now, what's the priority dispute you apply? You apply your Abigail and Lappin rule. So you're essentially trying to figure out whether Bree, whose interest comes prior to Alan's, IT Limited's, is postponed. So let's go to the answer because I can't remember off the top of my head. So Bree, yeah, she has a prior equitable interest. Will it be postponed? So really the thing here is Bree has a caveatable interest in the property because you can caveat constructive trust or a resulting trust. It's not a registrable interest, but the caveat system allows you to caveat even interest that can't be registered, except your equity that we spoke about in Swanston. So this is not a fatal factor. So you have to consider. So I think it's, I forget the New South Wales case where it's about the bank. It went to the High Court, 2 competing unregistered mortgages. Anyway, the failure to caveat is not fatal. So you have to consider the significance of the failure to caveat in the circumstances. So how I'd suggest you doing this in your exam is through what you would call the doctrinal bases that come out of the court in the High Court in Hyde, I think it's called Hyde Finance, Hyde Reliance, I don't know, the big one, the one with all the judges disagreeing. So it's not an arming case, so your reasonable foreseeability doctrine is clearly better, I think, to apply. It's hard to establish any conduct that could give rise to an estoppel. And I think it's Justice Murphy had an approach in the end of the Justice Murphy had a different approach. I think it was a strict approach. It is yet to be applied by any judge in Australia. So, I mean, you shouldn't apply it, therefore. So no disrespect to Murphy, good politician, good judge, but use reasonable foreseeability. So you'll be oscillating between the two, estoppel and reasonable foreseeability. You could also talk about estoppel and then advise or explain why it's not really appropriate because there's no sort of conduct that can give rise to a positive representation. All there is a failure to caveat. So it's a negative act. She's failed to do something, an omission. But the reasonable foreseeability doctrinal basis is effectively asking whether it was reasonably foreseeable to Bree their failure to caveat would result in a later equitable interest being created. This case is quite similar to the case of Jacobs and Platt. There's a family relation going on here. So consider whether it is reasonably foreseeable in the circumstances of the relationship. So would Bree think her husband would have betrayed her um, and then created a subsequent interest? I mean, arguably, because he's cheated on her. But I'd avoid that kind of analysis in your exam. Um, it's not a forum for gossip. So I think here the failure to caveat probably is not fatal. Um, and I think the examiner agreed with me in the year that they ran this exam. Bree wins. What does that mean? So Bree has equitable interest. She'll take her equitable interest free of, or it won't be encumbered by the mortgage. So IT Limited, got to go. You can only enforce it against the interest of Alan, who granted the mortgage. So if they've got a common intention constructing trust, it's 50-50 or whatever. Alan's interest is subject to the mortgage, but not Bree's. Her interest is pure. We're getting to the end. Well, this is terribly sad. Now, I have 23 more minutes to fill my quota. Now, let me see that there's another participant. Thank you for joining. Can you guys please figure out some questions you want asked, so I can fill my quota? Thank you. Or I will read these facts horribly slowly. RJ, and this is the final question on this exam, 2015 exam, that was relevant to your exam. It was hard to find, there was no, in the exam drive, which allegedly exists, there was no exam that was only about the stuff that's relevant to you. So I know last year there was an LSS tutor, thank you for her services, but she did an exam, half of it wasn't relevant, but she still went through it. So I wanted to sort of merge the two. So hopefully that was worthwhile. And that was 1 minute wasted. RJ, Bevan, and Celia resolved their differences in an amicable way and agree to sell the property to Darren. Now, Darren's going to get screwed over here. Darren pays the sum of $900,000. And rather than entering into a separate contract of sale, the parties execute a transfer in registrable form, and Darren registers it. And I do hope the participants are thinking of questions asked me. None of the parties were aware of the fact that shortly before the sale of the property to Darren, the Historic Artifacts Act 2015 Victoria came into operation. Section 17 states, and they've got the title of the act there. Let's read it. Section 17, approval of Historic Artifacts Commissioner required for transfers of property subject to Historic Artifacts Overlay. Subsection A, a transfer of property situated in a Historic Artifacts Overlay area must be endorsed with the approval of the Historic Artifacts Commissioner. What an important position. A transfer of property that does not comply with subsection A is absolutely void and inoperative and is of no effect. The property transferred to Darren, that is, that RJ, Bevan, and Celia are selling to him, they're in the Historic Artifacts Overlay area, and the transfer was not endorsed with the approval of the Historic Artifacts Commissioner. What is the effect of Section 17 of the Historic Artifacts Act? So, I mean, quite clearly, because there's a separate piece of legislation on the exam, like you can see here, Section 17, this is a question about inconsistent legislation. So the question you're seeking to answer is whether this statute works in implied repeal of the relevant sections of the Transfer of Land Act, sections 40 to 44, but particularly 42, which grant interfeasibility to the registered proprietor, that being Darren. So the general principles of this, and this is general statutory interpretation, the court will only work or find that the TLA was impliedly repealed if the subsequent statute, that being Section 17 of the Historic Artifacts Act, operates in the same sphere as the Transfer of Land Act and is so inconsistent with the Transfer of Land Act that grants indefeasibility, the relevant sections, that they cannot stand together. Now, you'd state that, you'd cite Horvath for it, then you would cite Horvath for the following proposition. that courts will do their best to read the two statutes in such a way uh, that it confines them to their respective spheres of operation. That fact will colour the rest of your analysis. So, as I said in my lecture on this, must be a couple of weeks ago now, how time flies. In this area, this exception to indefeasibility, you are simply looking for the closest or nearest case out of Horvath / Breskvar and Wall and Calabro versus the Bayside City Council. This is not anything like Calabro. Calabro, the statute, what did it do? It vested the fee simple in public highways in the council, which is obviously inconsistent with the TLA, which provides registration of a title upon legal title upon registration. So it's not Calabro. It looks very much like Horvath / Breskvar. Section 17B or A requires that a transfer of property gets the approval of the commissioner. The Section 17B says that a transfer of property that does not comply with A is absolutely void, inoperative, and is of no effect. So again, it's important to note here that the court will try to read that as separate to the TLA, and this is how they'll do it, according to Horvath. Remember, like a mortgage, that was the subject matter in Horvath, a transfer of land consists of two elements, really. There's a contract, there's a contract of sale, which RJ, Bevan, and Celia have entered into with Darren. And then there's the actual the actual registration of the title and the relevant transfer document, the contract of sale, which grants title. So the court will confine Section 17 to the contractual element of this legislation so that it can stand together with the TLA without working an implied repeal. So the outcome here really is that the contract of sale is voided, but it's well established, according to Horvath and Breskvar, and particularly Breskvar, that a registration of a void document, a void contractual document, still grants title. They're not inconsistent, these acts. They're in their different spheres. The TLA stands. Darren is the registered proprietor, and any claim by the Historic Artifacts Commissioner is irrelevant. One thing you can also mention, at common law, the contract of sale is voided, but so they've registered, so it's okay. But that means that on the common law view, that the other party can't sue the counterparty to the contract for breach of the contract because Section 17A voids it. However, remember your scope of indefeasibility. If you register a contract of sale, despite it being voided by Section 17A at common law, the covenant may also get indefeasibility too, because it's registered. So just remember that if required. But what time is it now? 8:15. That's all. Did you guys have any other questions? Is there anything you want me to talk about more? It's the last 10 minutes you'll have me for all semester, and I think your exam's in a couple of weeks now, so it's a great time to ask. Any questions? If not, I will spend the next. Oh, there's a question. This is great. Wow, it's a long one. 2 questions, Jessica. This is great. The first one, for a potential policy question, what sort of arguments could you make regarding the exceptions of indefeasibility and saying they're too wide because they undermine the very concept of indefeasibility, or saying each exception under Section 42(2)(e) are very adequate? Right, good question. A common exam policy question, or at least one that's in the reading guide and the PowerPoints, and was definitely found by me in my search for relevant policy questions. What would I say about this? I would note the strength at the outset of the indefeasibility provisions, um, and go through some of the sections, some of the specific exceptions to indefeasibility. Um, there's a whole range of them, but you have the fraud exception, which is, I think, a very common sense exception. So you can note that, like, even if it does water down indefeasibility, um, it would be unacceptable to not have to have actual fraud as an exception to indefeasibility. It should be there. In personam, uh, I think you can make the argument the in personam exception uh, is not really an exception to indefeasibility. It's just allowing other areas of the law to come into property. So again, the basis of the in personam exception is that you can't stand on your registered title to defeat a claim that you've created with your own conduct in respect to that property. But that's not so much of an exception. It's really just trust law or contract law or property A, that if you create a transfer of land, if you execute a contract to sell the property to somebody, um, you can't then resile from that contract and say, no, uh, I'm indefeasible. You've created a cause of action against yourself. So it's not so much an exception, but rather just permitting other areas of the law to operate. Um, so I'd mention that too. Uh, so, that exception is not too broad. Then you can go through the section 42(2)(e) things, and there's a whole range of them. Sorry, 42(2), and there's a whole range of exceptions. But really, none of them are very substantive. You have the Crown grants exception, that anything noted on the original Crown grant uh, is in binding, even on a later registered proprietor. You have stuff about uh, you have stuff about you know the local council still be able to charge rates against a new registered proprietor, even if uh, the rates were incurred before the registered proprietor became the registered proprietor. You have adverse possession still applying against a registered proprietor. They can't, if they're not in possession of the land, the fact that they're registered doesn't protect them. It sounds broad, doesn't it? Like there's a whole list of things that are exceptions, but they're useless. Like they are very niche, very very niche um, exceptions. Uh, the other exception you learn about, uh, the inconsistent legislation exception. Uh, they call it an exception, but all it is a recognition that the Transfer of Land Act is not constitutionally enshrined in Australia. Obviously, it's a statute, so it can be implied by another, repealed or altered by another statute. It's just an operation of basic statutory or parliamentary supremacy principles, uh, or basically constitutional principles. Uh, it's really not a considerable exception that the Parliament can overturn a statute that they've created. They can do that with everything. So I think you can discuss the different exceptions and basically say that they're not too broad because they apply nichely. They may not even be true exceptions. You can go read some literature on that in the reading guide. There's a few articles that are quite good. But no, I don't think it's broad at all. I think it's, sorry, just give me a moment. Apologies. Um, but yeah, where was I? Yeah, no, the indefeasibility provisions are very, very broad. They're very powerful. There's a lot of exceptions, but they do not undermine them. And you just work through the different exceptions and explain that. Hopefully that's satisfactory, Jessica. I think that's the way I would have gone about it on my exam, and I prepared quite hard for it. Um, but I think it's really important to keep in mind the strength of the indefeasibility provisions when you're going through them. Um, so the exceptions aren't too broad. They're very small scale, often useless. So that's the answer. Now, your second question: what is the difference between Section 51B II and Section 51B III? I find the wording rather confusing. II to purchase, renovate, or improve residential property for investment purposes or refinance credit that has been wholly or predominantly used to purchase, renovate, or improve residential purposes. Yeah, so this is about the NCC and whether something is a code protected purpose. Yeah. Uh, so double I is not too difficult. It's just about when you're borrowing credit to purchase, renovate, or improve residential property. So that's clear. Triple three, though, is aspect where you're finding it difficult because it seems similar. It's just about refinancing, which basically means you have an existing mortgage, but you take out a different mortgage to change the structure of the finance, which basically it's altering the the loan that you have. So you've got a loan that's directed towards purchasing, renovating, or improving residential property. That would be under double I. But under triple I is where you have refinance credit. So you've had that original loan and then you've borrowed more to change your finance structure, or you've changed the terms on which you've borrowed from that original lender. So it's just that second round of negotiation or financing, basically. But I wouldn't get too hung up. I'd be very surprised if triple I came up. Double I, fair game. That one's pretty simple once you understand what triple I is. Um, but I can re-explain it again. But yeah, triple I is more so about altering existing finance with a bank for the purposes of purchasing, renovating, or improving residential property. Double I is about that first mortgage, uh, first loan to do that. So the first loan to purchase, renovate, or improve. So hopefully that's clear. But no, please ask again if it is not. Uh, Valentina has asked, would you be able to explain all money's mortgages versus traditional mortgages? Yeah. Um, Another thing I wouldn't be too stressed about, uh, I think it used to be a very big component of the course and topic three back in the day, before my time as well. But basically, uh, an all money's mortgage, we'll go with traditional mortgages first. A traditional mortgage is when you go to the bank and say, I'm borrowing $1,500,000 today. And then you'll put up security for it, your existing home. Uh, and that's the mortgage. And you'll have a mortgage agreement, which is basically there's a loan agreement that you're gonna register a memorandum of mortgage, and on that document it will contain the covenants to repay and how much you've borrowed. $1.5 million it will be, let's say. You can then go and register that, and because the amount you've borrowed and the amount you're going to repay the uh, is on the loan agreement that's being registered, it's indefeasible too. The scope of indefeasibility extends to it. So that's your traditional mortgage, pretty straightforward. But all money's mortgages, and indeed they're far more common these days, it's a more flexible lending arrangement with a bank. So rather than in the traditional mortgage sense that you go to the bank and say, give me 1.5 million and I'm leaving today. Here's a security interest over my property. Go register it, off you go. And all money's mortgage is what's called a lending facility, I think. But don't need to worry about that. What it means is that it's unclear how much you've borrowed in an all money's mortgage. Uh, what the bank does do is it sets aside a pool of funds. Say they open up an account and there's 1.5 million in it, and you can draw from it as and when you like. So it's not like you're leaving the bank that one day with your 1.5. You're leaving the bank, you've given them the security interest, and then you have a pool of funds with the bank that you can draw on. But until you make those drawings, you have not borrowed funds. You've made funds available for borrowing. And the reason that's important to understand is because it helps you understand the nature from a document basis or a document perspective, the all money's mortgage. Because you haven't borrowed anything, and the money that you could borrow is sitting in an account at the bank, it's impossible for the bank or the memorandum of mortgage that the bank's going to register to have the amount you've borrowed and your personal covenants to repay. Um, so they're going to be registering a bare mortgage basically without those covenants because it's not clear what you've borrowed yet at the time they're registering their mortgage. You may not have borrowed anything. Um, so uh, that's the difference. And the all monies mortgage will not have your personal covenant in the document, which means that um, it's not as easy to establish that that covenant to repay is indefeasible, like it is in the traditional mortgage. And you will have to make sure, or the only way that the covenant to repay is indefeasible is if the registered memorandum of mortgage makes sufficient uh, reference to the off-register loan agreement between the parties. And if it doesn't do that, it's not indefeasible. It's a bit complex. Um, again, don't stress about it too much. Okay. Natalia, could you explain how the cap on compensation under Section 110.4 works for fraudulent mortgages in power of sale situations? Okay, so Section 110.4 links up with section, and I did a video on this as well. So if you want to go review that for a bit of a nicer, a more thought out explanation, you can, but I'll explain it again because it's an interesting question and a hard one. Um, Section 110.4 has its relation to Section 87D and E in respect of sales questions, uh, powers of sale. So let's say they exercise the sale, they sell the property. So you're in the realm of 87E. You establish all the preconditions to 87E applying, which they're in the statute. I did a video about that a couple of weeks ago, my compensation scheme thing, or last week, or yeah, a couple of weeks ago. Go watch that. But let's jump to the end, the good stuff. Uh, they've sold the property, and it's really relevant for shortfall situations. So what Section 110.4 does is it limits the amount the bank can claim uh, from the sale uh, to either the lower of the value of the property at the time the mortgage was registered, or B, the cost of the debt or the loan, the debt that they had with the borrower who's defaulted. So I'll give an example to make sure it makes it some sense. Um, okay, I've got a house worth bugger all 200,000, let's say. Now I want to go get a mortgage for 600 grand, and as security for my loan, uh, I put up my house and I default because, you know, I didn't get a clerkship. I don't know. It's next year for me. So I didn't get a job, and I can't afford anything, least of all my mortgage. So the bank sues me and they sell the property. It doesn't cover the value of their debt though. I took out $600,000. My property's worth $200,000 when they mortgaged it. So what Section 110.4 does is it limits the amount the bank can claim to the lower of A, the value of the property at the time the bank was taking the mortgage, or B, the loan, the debt that I had. So the debt I had was 600. The value of the property was 200 at the time the bank took the mortgage. So they are limited to $200,000. And how it's relevant to compensation is that the bank or the statute is trying to tally the amount the bank can claim with the amount that the defrauded mortgagor can claim. So the bank can claim $200,000 under the statute, and that tallies with what the mortgagor can claim. The mortgagor can go and claim $200,000. It brings it into parity. So yeah, it's the lower of those two amounts: cost or the value of the house, the property that was secured at the time the mortgage was taken, and B, the debt. That's great. Hopefully that answers it. That is probably one of the more complex parts of the course. I really hated that. Okay, another question from Jessica. If you still have, I do have time. Do I? Oh, I'll go over because you guys have been great asking me questions. You got me out of a sticky situation there. When identifying a criteria from Section 110, subsection 1, for an entitlement of indemnity, would it almost be section 101, 101B you would apply? I'm presuming that's the section that says something about loss caused by the registration of somebody else uh, on the title. Uh, in that case, yes, it is. That's very correct. It is the broadest one. Um, I mean, for mortgages, there's going to be a registered mortgage, most likely. If it's not a priority disputes question, it's a question about indefeasibility. There'll be obviously a registered mortgage. So there's someone who's registered and you've lost because of that registration. So yeah, it almost always is the one that you'll apply. Um, but yeah, no, that's great. Definitely do list that down though as part of the process for discussing entitlement to compensation. But I'll open up the floor one last time. Uh, any further questions? You can each have one more question if you'd like. I'm feeling very charitable today. But if not, we'll wrap it up. And no, thank you for your attendance today. If there's no further questions, and yeah, hopefully you've been watching the tutorials throughout the semester, and they're of some vague assistance. Um, I think they were good. So yeah, if that's all, have good luck with your exams and everything. Um, and yeah, good luck with your exams. Uh, and study hard. Go into the exam drive and do the practice exams. It's just like VCE. Oh, wow. Okay, yeah, no, thank you, Natalia. No questions. That's great. Yeah, excellent. Good luck, guys. When will the recording be up? It will take probably about 45 minutes to download. I have to study for trusts, so definitely by the end of the night. So watch it tomorrow morning, or if you're up at 2 a.m., like I will be. Uh, yeah, the recording will be up later. Very good. Cool. Gonna stop the recording.